This Honorable Court of Appeals of Tennessee is now in session.
All right, gentlemen, thank you for agreeing to participate in this oral argument via Zoom. We appreciate both you and your clients agreeing to do this. Before we get started, I want to stress that we are going to follow the same rules and procedures as if we were standing in the courtroom today. So all rules of appellate procedure and the rules of the Court of Appeals are applicable to this hearing. Each side will have 15 minutes to make its oral argument. If the appellant has reserved rebuttal time with Mr. Hibner, he will receive that rebuttal time. Before we get started, I want to introduce today's panel. We have Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Mr. Hibner, anything we need to take up before we call the case?
No, Your Honor.
All right, you may call the case, please.
Willie Adams versus Illinois Central Railroad Company.
All right, we will hear from the appellant.
Good morning. My name is Thomas J. Joyce III. I'm an attorney with Byrne Capelli, and I represent the plaintiff and the appellant, Willie Adams. This case involves an order from Judge Allen from Madison County dismissing the plaintiff's case, excluding the plaintiff's expert witnesses for failure to comply with an agreed scheduling order. One of the comments that Judge Allen made during we had a hearing or an oral argument on the motion to exclude the plaintiff's experts on July 17th, 2020. One of the things that Judge Allen put on the record was, this is a situation where COVID-19 had no effect on this case. And with all due respect to Judge Allen, COVID-19 had something to do with this case. The history briefly is, we filed this lawsuit originally in Shelby County in January of 2018. In August of 2019, it was transferred to Madison County. We had a scheduling order issued January 15, 2020. One of the deadlines was the plaintiff's expert reports were to be disclosed by March 17th. We did not do that. That was a mistake on the plaintiff's counsel's part. I accept responsibility for that. As soon as I was alerted to the fact that we missed the expert reports, I got an email from defense counsel. And the next day I sent him an email confirming that we were using Dr. Vance as our liability expert and Dr. Blickenstaff as our medical causation expert. And I sent the doctor's CVs. The other deadline that was a problem for us, and this is directly related to COVID, was the court's scheduling order called for the expert depositions to be completed by May 29, 2020. Our office was shut down from March 13th until May 31st of 20 because of COVID.
Let me stop you just a minute, Mr.
Sure.
Joyce, and ask the question. I've read the transcript of the hearing. I've read the briefs. My question is this: what evidence of any of this is in the record before the trial court? Were there affidavits filed? Did anybody testify?
There's no affidavits filed, Your Honor, but there certainly is. This is part of the notes of testimony from the argument.
No, wait a minute. Arguments are not evidence.
I understand.
What evidence did the trial court have to consider why the scheduling order was not complied with? And let me add another layer to that, and then I'll give you the opportunity to respond. Was a motion to amend the scheduling order ever filed, or was a motion to continue the trial date ever filed?
A formal motion was not filed, but prior to the court's ruling, I had requested a continuance. I also requested that defense counsel agree to modify the scheduling order prior to the hearing, and I was told the railroad would not do that. So I did make the attempt, but a formal motion to amend the scheduling order was not filed.
And again, no evidence was before the trial court other than the argument of counsel. Is that correct?
Other than the fact that as part of our papers, we submitted the expert reports of Dr. Vance and Dr. Blickenstaff when we provided them to defense counsel. That was part of the record as one of the exhibits, but there were no affidavits, Your Honor.
Right. I'm simply trying to ascertain what evidence was before the trial court for it to consider in making its determination as to what it did.
And other than the fact that there were reports attached to our responsive papers, there were no other substantive evidence, Your Honor.
All right, thank you.
In terms of abusive discretion, that's what the theory is in terms of the appellant's case. We know that from State v. Banks, the Tennessee Supreme Court says when you're looking at abusive discretion, Reviewing courts will find an abuse of discretion only when the trial court applied incorrect legal standards, reached an illogical conclusion, based its decision on a clearly erroneous assessment of the evidence, or employed reasoning that causes an injustice to the complaining party. Obviously, that last one is the plaintiff's contention, is that the judge's ruling caused an injustice to the appellant, Willie Adams. When we look at the case law that really applies here in terms of assessing whether what the options were at the court before the case was dismissed, the Lyle v. Exxon case is the important case to look at in terms of the factors. And the Tennessee Supreme Court in Lyle v. Exxon said there are 4 things the court should consider in determining whether or not to sanction a party or strike experts. One is the party's reasoning for not providing the challenged evidence during discovery, the importance of the evidence, the time needed for the other side to prepare to meet the evidence, and the propriety of granting a continuance. I explained the reasoning to the court on the record July 17, 2020, that our problem was we were 30 days late with the expert reports. The problem that directly relates to COVID is that neither one of our experts, Dr. Vance nor Dr. Blickenstaff, were willing to give any type of depositions prior to the May 29, 2020 expert deposition deadline. And so I did not have the power or the control to be able to present them for depositions prior to the court's deadline. So that was the issue that's directly tied to COVID. I did submit an email to Judge Allen at the time we filed our motion to alter or amend from Dr. Blickenstaff, explaining why he was not willing to appear for depositions because he's in his mid-70s and he was concerned that he was at a higher risk of getting COVID. Similarly, Dr. Vance also is in his late 70s, who also obviously is at a higher risk. So my contention here, Your Honor, is that there was an opportunity here to sanction, a lesser sanction would have been appropriate. In fact, a continuance was probably the most appropriate thing here. But the reality is COVID did impact this case. This is not just simply attorney neglect. This is a situation where we were in the heart of the COVID situation. And I think the problem is Judge Allen considered the prejudice to the railroad, to the Illinois Central, but really never considered the prejudice to the plaintiff. Willie Adams, we never balanced any prejudice to Willie Adams if his case was going to be dismissed. We had a meritorious case in that we had the ability to put the case on to get it to a jury. If the experts are allowed to testify, we had a liability expert that can prove negligence under the Federal Employers Liability Act. We had a medical causation expert. We had the ability to get to trial with the jury if the court allows, if Judge Allen allows the 2 experts to testify. The other case I think is important is, well, the 2 rules. Let's start with the rules real quickly. We know that Rule 1606 of the Tennessee Rules of Civil Procedure states, when a party or party's attorney fails to obey a scheduling or pretrial order, the judge upon motion or the judge's own initiative may make such orders with regard thereto as are just, including any orders under Rule 37.02. Again, as are just is really what I'm focusing on here. If we look at Rule 3702B, it states, if a party fails to obey an order to provide or permit discovery, the court in which the action is pending may make such orders in regard to the failure as are just. Again, this is this whole, was there any consideration for Mr. Adams's position if the court in fact dismissed the experts? The other thing about this is one of the issues we have with this is there were really 2 really simple fixes. One was, and this goes back to, I guess, our relationship or lack of relationship with the defendant is, everywhere else across the country with the COVID-19 pandemic, we were routinely getting agreements from counsel to extend deadlines in cases where the orders had been entered before the COVID pandemic hit. And routinely, we were getting extensions on expert report deadlines and trial dates and things like that. I did not ask Mr. Kostakis, who's Mr. Peters' associate, for an agreement to modify the order until I was there before the hearing with the judge on the 17th of July, 2020. The other thing is the order itself. The order itself called for bear with me for 1 second. The judge's order, Judge Allen's order that was dated January 15, 2020, actually had a provision in it at the end, paragraph 13. The schedules and deadlines set forth herein may be modified only by written consent of counsel for all parties or by order of this court upon sufficient cause shown. So the first thing I tried to do was get the other side to agree to extend the deadlines like we've done in most other cases during COVID. I did not get, that was not something that Attorney Kostakis was willing to do. At the actual hearing itself, the other thing that the railroad was raising as prejudice was they did not have the opportunity to depose either Dr. Vance or Dr. Blickenstaff. At the hearing, I offered to make both of them available for discovery depositions prior to the original trial date, August 12, 2020. I offered to make them available. I explained to Judge Allen why I couldn't make them available prior to May 29th, but I did offer to make them both available. It's not like there was going to be some sort of trial by surprise or trial by ambush for the Illinois Central. I was not certainly holding the deadline over their head to say, no, that you don't get their discovery depths. I was offering to make them available to cure any potential prejudice against the railroad. Obviously, the court did not. My ultimate request with Judge Allen was, Judge, if we move this trial date for a couple of months to the fall, we will certainly make our experts available for depositions. There'll be no prejudice whatsoever to the defendant. The court was not willing to change the trial date. The trial date of August 12, 2020 was set in stone for Judge Allen, even though I thought we had legitimate reasons, in part related to COVID. But Judge Allen, determined, exercising his discretion, that it was not appropriate to move the trial date, and that's where we claim the abuse of discretion. I mean, this could have been resolved. Simply by modifying the scheduling order and allowing the expert discovery to take place. It was not, obviously, and we're here because I'm sure that there's a lot of situations. I don't know what this court's been doing in terms of other cases involving COVID, but this is not a situation we're just prying COVID because it happened, the timing happened to exist. The reality is COVID had an impact on this particular case. One thing about these cases we know, and this comes from not only the FELA, the Federal Employers Liability Act, is a humanitarian statute, and FELA cases are supposed to be decided on the merits. The Tennessee Supreme Court says the same thing. Cases should be decided on their merits whenever possible. That's the Bates v. Sanders case. It's contained in our brief, but the reality is that, we've got an individual through no fault of his own who has colon cancer, who also, by the way, being a colon cancer patient, had a risk, which I explained to the court as well, of going forward to trial in August. I explained to him that not only were our doctors at risk because they were in their 70s, and they did not want to participate in deaths before the deadline, but I also explained to the court that Willie Adams, being a colon cancer survivor, also was at increased risk of going forward with the case the way it was. So at the end of the day, the judge, I believe the judge abused his discretion. Thank you.
Thank you. We'll hear from the appellant, or excuse me, appellate.
May it please the court. I guess the first thing I'll address is the point concerning the two firms having a relationship, which I quite believe that we did. We have several cases. These cases are part of hundreds of cases filed across the country, of which I am defense counsel on a good many of them. And what Mr. Joyce tells you is we had this relationship, yet the first thing he did to reach out to his relationship partner was on the day of the hearing. 4 months after deadlines were blown, after we had to disclose without having anybody on our access to any real information from our standpoint. I mean, we got reports 2 days before our experts were required to do their reports. And while Hollins, our IH, mentions them, she didn't have the benefit of breaking them down like she would have had the order been complied with. So if you have a special relationship, it seems to me that the first thing you do isn't to request a continuance on the day of a hearing where the motion to exclude is being heard, where it's already been pending for a month and a half, where the date that you wanted to change passed 5 months prior to the trial and 4 months prior to the hearing. So I think that argument cuts against the plaintiff in this case, Your Honors. When we get to the idea of COVID and the supposition that the plaintiff starts with concerning COVID having something to do with this case, and apparently that's the part of the order they focus on as the judge's error. Your Honor, I think it's quite clear COVID had nothing to do with what happened in this case. What we have are two claims based on COVID. Number one, the plaintiff's office was rearranging to remote work, but there's no information about how that meant they couldn't answer our letters requesting depositions. They couldn't answer our letters requesting reliance materials, and how they couldn't return our phone calls. We were a good partner to work with. We reached out repeatedly. And all we got on the other side, Your Honor, was silence. So I don't understand. It seems to me for remote work location to be a reason under COVID for the problem that occurred in this case, we'd have to have some information that phones got changed or numbers got deleted or phone reception was bad or emails didn't come through. And we don't have any of that. None. The second thing they claim, as far as COVID having an impact, is that the March 13th order of the Tennessee Supreme Court, which they misconstrued as giving them additional time under the order. Number one, that was corrected and made very, very clear and clarified. I shouldn't say corrected, clarified and made clear on March 30th, and we still never got depositions of experts. We still never got a supplementation of the Rule 26 requirements. But the thing that I find interesting about that claim, that they relied upon that order, I think the judge found this interesting as well, is their original due date was the 18th. If they're relying on that order on the 13th, surely their experts weren't putting together all this information in 5 days. In other words, they hadn't yet contacted their experts on the 13th for their opinions to be, their disclosures to be due completely on the 18th. Yet we get no information concerning what's going on as far as why these experts didn't complete their report because of some order saying it didn't have to be disclosed. Now, if they had come back and said, we had the order and we had the reports and we held it because of the order, if there was some evidence of that, that might be something. But are we to believe that they called the experts and said, hey, look, I know you're working on this and now you were required to do the 18th, but you may have more time. So you all just kick back and we're not going to do anything here in these next 5 days. I mean, that doesn't make any logical sense, and it didn't to the judge. It's also belied by the fact that when they got around to actually disclosing the individuals, they gave us names contrary to the names that were in their initial Rule 26 unverified disclosure. We initially disclosed Michael Ellenbecker and Roy Berger. So they gave us two new names late upon our request again, but for some reason, these names are given us on the 26th of March, and then we don't get the reports until 20 days later. Well, if COVID really was the reason, wouldn't they just be 5 days away from doing their compliance anyway? I mean, the order came in on the 13th. They were due on the 18th. But instead, they needed 20 days. So there's no evidence that there was really any type of effort on behalf of the plaintiffs to comply with the March 18th deadline. None. So COVID had nothing to do with this case. And then to further belie that is what's happened after the Tennessee Supreme Court clarified their order. They disclose the experts upon our request, then they actually do reports, which we get on April 15th. Now, once again, what counsel for the petitioner indicated was, yeah, we know we're late. Now we know the order applies. But the first thing we do to contact or let anybody try to work out an amended scheduling order is on the day of the hearing, 3.5 months later. I mean, I would think April, and I think the court felt as well that April 1st would have been a nice day for that if you really were misled by the March 13th order. April 1st would have been a good day. Or maybe April 15th when the reports came out. Or maybe April 16th when we requested depositions. Or later that the next month where we requested the reliance materials on May 1st. All those would have been an excellent opportunity to do the first thing, which is approach the defense counsel or the court to amend the scheduling order because there was a basis or a reason to do so. All those opportunities were squandered. And it's not just that the defense counsel was sitting on their hands. They were contacting the plaintiff and prodding them. And yet still nothing, no request to amend the order. And I quite frankly, Your Honor, I'd have to tell you that if we had a request, certainly before our time expired, based on our relationship, it would have been worked out. But then they have another opportunity to start talking because we're forced in May to file the motion for exclusion. So on May 27th, we do so. There's been no depositions as far as that were due by the 29th. And again, they get the motion to exclude. Seems like a pretty good opportunity to have a discussion about it. Now, we already had to disclose our experts. They were already disclosed. We complied with every requirement of that scheduling order. And that's where the real prejudice exists in this case, to the extent you need it. But instead of reaching out and trying to amend the scheduling order once they receive the motion to exclude, they just respond to it and say, COVID was a problem. Then we filed a motion for summary judgment. I believe that was on the 11th of June. And a reply brief as well. Again, another opportunity to reach out and say, well, we've got a problem here. Let's see if we can fix that. But nothing happened. Nothing. And it wasn't until the day of the hearing that they reach out and speak about continuance, saying, well, you can do a discovery deposition. We could do an evidence deposition right after on the same day, or maybe later, or maybe this, or maybe that. At a hearing where he's speaking to my partner prior to the hearing, not even a call the night before. So COVID had nothing to do with this case. As far as this reliance on Lyle, it's quite clear that if the violation with respect to the evidence is, as in this case, where it is knowing and deliberate and bordering on contumacious, if not there, you never get into the Lyle factors.
Well, that brings me to my original question to opposing counsel. What is the evidence that the court had to consider here besides the scheduling order and the failure to comply? What did the court have in front of it?
I think all it had is the arguments of the plaintiff's counsel that it took at its face value, subject to its critique of those. I don't think the court actually held an evidentiary hearing. I think the court was at the motion to exclude based upon the explanations from the counsel from the plaintiff's counsel himself. I believe on that basis, the court found, in other words, the evidence of the argument of the coming out of the very mouth of the person who was responsible for the disclosures was the evidence that was considered, the argument.
With all due respect, argument of counsel is not evidence.
And I, Your Honor, I agree with that. But what the court did was accept what Mr. Joyce told him at face value as if he had proof of it.
Well, the standard here is abusive discretion. And I'm attempting to ascertain, the first thing we have to ascertain is what facts the court relied upon to determine its course of action before we can determine if the court abused its discretion in deciding what course of action to follow. So what I am hearing from both of you is that the evidence, the facts that the court had to consider was you had a scheduling order, you had a trial date, and you had a failure to comply with the scheduling order. Am I missing something there? I know both of you discussed at length what both of you did as far as your relationships and attempts to comply. But until that is put in some kind of affidavit form or testimony, can we even consider that?
Well, I believe so, Your Honor, simply because there were affidavits below concerning the violations of the order. And so what the court had is everything it needed to determine, number one, that the order had not been complied.
I haven't seen those affidavits. What affidavits are you referring to?
I believe there's an affidavit of Brooks Kostakis indicating the dates in which he made phone calls and also supporting the record, I believe.
You believe that's in the record supporting the motion to your motion, I assume?
I believe that is, Your Honor.
Okay.
Hopefully I'm not mistaken on that. I believe that's the case.
Yeah, let me ask you, Mr. Peters, what was the prejudice to the railroad by this late filing? And based on what I heard you argue, the late filing was like 8 days late. What was the prejudice to the railroad by this late filing?
Well, the initial prejudice on the initial late filing was we had to proceed with our experts anyway. And these cases are not simple. There's 20, I should say 20. There's numerous different exposures that are alleged in the complaint. But when they do their expert reports, there's only a handful. We had to not only respond to those, everything in the complaint and everything else that was brought up by Mr. Adams at his deposition, not just the ones that plaintiff we're going to focus on in their actual reports that they actually filed. So we did all that before. Number two, we had to go and disclose our experts, which normally is supposed to be responsive. Plaintiff has the burden. We had to go 2 days later. Our experts' reports were due after their reports were due. And then normally you actually have the depositions before you do your disclosure, so you can actually narrow what your response will be. We never got that. So we've sitting here where we had to show our hand before the plaintiff had to show theirs, which is not particularly the way it should be.
I know you had a trial date in August. Obviously, this case didn't go to trial. To your knowledge, was the trial judge in this case conducting trials in August?
He had advised us that he had, in fact, conducted a trial on it. I don't know if it was him, but the courthouse, a criminal trial.
A criminal trial.
That's what he had advised us, yes. And he was planning on proceeding on August 12th.
Okay.
Thank you.
Let me ask you one question, Mr. Peters. You have suggested in your oral argument that the Lyle factors, or that the court is not required to follow the Lyle factors based upon the conduct of opposing counsel. Where do you get that from?
I get it from the cases which distinguish the application of Lyle. I think one might be Lassiter, where they actually indicate that the distinguishing characteristic of Lyle is that if it is deliberate and knowing, that the Lyle factor, the actual application of the factors don't apply. There may be a case called Cuddleston that says that same thing.
Well, I'm looking at the order that the court filed in this case, and I may be overlooking it, but I don't see anything where the court made that finding that it was deliberate and knowing.
I don't think he used those exact words, but when you see the statement where he says that COVID-19 had nothing to do with it, I think that's what the finding is.
Okay, I understand your position, but that's, so you're saying that a finding of deliberate and knowing would excuse the application of the Lyle factors?
I do, Your Honor.
Okay, all right. Thank you, sir.
Thank you.
We will hear rebuttal from the appellant.
Briefly, Mr. Peters called me, I can't even pronounce the word, Contumacious. I had to look up the definition for that. What it means is stubbornly or willfully disobedient to authority. So that's what Mr. Peters is accusing me of. Just for the record, there's nothing in this that was knowing or deliberate. This was not some strategy on my part or my law firm's part to somehow game the railroad and take advantage of them during COVID. If anything, it's the exact opposite. Judge Armstrong, you made the point that where was the railroad's prejudice? The reality is the railroad was not prejudiced in any way. The railroad is just simply feigning prejudice because they have an opportunity to take advantage of COVID-19, which in reality is what really happened here. So I just simply asked the judge to balance the prejudice between the railroad, where I offered to cure any potential prejudice by offering to make the depositions happen, by offering to continue the trial so there would be no prejudice on the part of the railroad. But when it was all said and done, the only thing that Judge Allen considered was the agreed scheduling order and the dates and any potential prejudice to the railroad. Not once was there any discussion at the hearing before our experts were excluded where the court considered what are the ramifications or the effects on Willie Adams if his two experts are excluded. And the reality is, without the experts on negligence, without the experts on causation, the plaintiff can't prove his case under the FVLA. And that's why on the record, I told Judge Allen that if the court excludes the plaintiff's experts, then summary judgment's appropriate. I know Mr. Peters is arguing that we waived the summary judgment argument, but the reality is the two go hand in hand. We have to concede that if we don't have expert testimony, that under the FVLA, we cannot prove our case. So once the court makes a decision that our experts are barred or excluded, I have to concede as the plaintiff's counsel that I don't have the ability to meet my case with a prima facie case. Therefore, summary judgment would be appropriate. But the reality is that this is all about, was it appropriate? Did Judge Allen abuse his discretion in excluding Dr. Vance and Dr. Blickenstaff? And I think I heard Mr. Peters about 3 or 4 times say, COVID had nothing to do with this. The reality is COVID had something to do with this. The biggest thing COVID had to do with this was I could not produce my expert witness for depositions. That was the biggest thing I had no control over. In hindsight, I should have picked up the phone and called Mr. Peters and said, Tom, I have a problem with my experts doing deps because of COVID. I would do that if I had another chance. But the reality is when you're looking at this and you're looking at whether or not Judge Allen abused his discretion and whether or not the railroad, the appellee here, was actually prejudiced, the railroad was not prejudiced. In fact, the only person prejudiced by the court's ruling was Willie Adams, and that's why we're here. Thank you.
Thank you, gentlemen. We will take this matter under advisement and attempt to issue a ruling at the earliest possible time. Mr. Hibner, if you will recess court to the call of the next case, please.
This honorable court is now in recess until 1 p.m.
Thank you.
Thank you.